Section 13. What are you really buying? Understanding the title commitment. When we left Ashley in Section 10, escrow had officially opened. Her earnest money had been delivered, according to the transaction requirements. Maria was coordinating escrow, and Daniel had given Ashley a warning she would hopefully remember for the rest of her real estate life. Never send money based solely on emailed wiring instructions without independently verifying them through a trusted source. Ashley was finally starting to relax when Maria said, "We'll send the title commitment when it's ready." Ashley immediately looked at Daniel and asked, "What's a title commitment?" Daniel smiled, because this is one of those documents buyers frequently receive, quickly scroll through, and then ask their agent, "Do I really need to read all of this?" The answer is yes. The title commitment may not be as exciting as choosing countertops, but it can tell Ashley important information about the ownership she is preparing to acquire. Daniel explains it in simple terms. A title commitment is generally a commitment from the title insurer describing the conditions under which it is prepared to issue a title insurance policy. It identifies important information about the proposed insured transaction and lists requirements and exceptions that may affect coverage. It is not simply a certificate saying everything is perfect. That's one of the first misconceptions Daniel wants Ashley to avoid. Ashley asks, "Didn't the seller already prove they own the house before they listed it?" Not necessarily in the way Ashley is imagining. The title company examines public records and other information relevant to the transaction to determine the state of title and what must occur before the policy can be issued as contemplated. Depending on the property, the commitment may reference deeds of trust, liens, easements, CC&Rs, taxes, assessments, rights of way, and other recorded matters. Daniel gives Ashley a practical example. Imagine the backyard has a beautiful block wall, and Ashley is already planning where she will install a pool. Then the title commitment identifies a recorded utility easement affecting part of the property. Does that automatically mean she cannot install the pool? Daniel shouldn't guess. The easement document needs to be reviewed, and depending on Ashley's plans, additional investigation with the appropriate professionals or governmental authorities may be necessary. The important point is that Ashley needs to know the easement exists before she makes assumptions about how she can use the property. This is where many agents get into trouble. They see an exception for an easement and tell the buyer, "That's standard. Don't worry about it." Maybe it won't materially affect the buyer's intended use. Maybe it will. The agent shouldn't dismiss a recorded matter without understanding it. Michael's broker rule for title documents is simple. If you don't understand it, don't minimize it. Investigate it. Ashley continues through the commitment and sees references to CC&Rs. Daniel explains that covenants, conditions, and restrictions may impose private restrictions affecting the property. Depending on the community and documents, they may address architectural changes, property use, parking, leasing, pets, maintenance, and other matters. The title commitment may identify recorded documents, but Ashley should actually review the applicable documents and HOA disclosures rather than assuming every community operates the same way. Then she sees another item and asks, "What is a deed of trust doing on my title report? I haven't even bought the house yet." Daniel explains that the existing seller may have financing secured by the property. As part of closing, existing liens or other matters that must be satisfied may need to be addressed, so title can transfer in accordance with the contract and title requirements. Maria and the title company coordinate those issues as part of the closing process. This brings us to an important distinction. Title isn't just about who owns the property today, it is also about what may affect that ownership. A buyer can receive ownership of a property while remaining subject to valid easements, restrictions, taxes, assessments, and other exceptions. That is why title review is part of buyer due diligence. The Arizona Realtors Residential Resale Real Estate Purchase Contract contains provisions addressing title and the buyer's review of title information. Daniel should know the applicable contractual deadlines and make sure Ashley understands that receiving a document isn't the same as reviewing it. An email sitting unread in the buyer's inbox doesn't protect the buyer. Ashley asks Daniel the dangerous question, "Can you tell me whether all of these exceptions are legally okay?" Daniel explains that he can help her understand the real estate transaction, identify documents, discuss the contractual process, and help her obtain additional information. But interpreting the precise legal effect of a complicated easement, deed restriction, ownership dispute, or other title matter may require legal advice. A real estate license doesn't turn Daniel into a title attorney. Here's where experienced brokers teach agents to resist the urge to sound knowledgeable when the better answer is, let's get the right person involved. Daniel can contact Maria for clarification regarding the title commitment and title process. Ashley may review recorded documents. If a legal question exists concerning her rights or obligations, she can consult qualified legal counsel. Ashley then asks about title insurance. Daniel explains that title insurance is different from homeowners insurance. Homeowners insurance generally addresses covered future losses involving the property under the policy, while title insurance addresses covered title risks according to the terms, conditions, exclusions, and exceptions of the title policy. There may be an owner's policy and a lender's policy serving different insured interests. A lender's title policy protects the lender's covered interest. It should not simply be assumed to replace the buyer's owner's coverage. By the end of the conversation, Ashley understands why the title commitment matters. She isn't merely buying walls, a roof, and a kitchen. She is acquiring legal ownership of real property that may be affected by recorded rights, restrictions, liens, easements, and other matters. Then Daniel receives another email. The subject line says, Seller's Property Disclosure Statement. Ashley looks at him. Another document? Daniel laughs. Yes, and this one we're definitely going to talk about. The title commitment helps Ashley investigate ownership. Now the seller's disclosures are going to help her investigate what the seller knows about the property. That's where our journey goes next. Online discussion 1. Ashley sees a utility easement listed in the title commitment and asks Daniel whether she can still build a pool over that area. How should Daniel respond? Answer. Daniel should not guess or guarantee what Ashley can build within the easement area. He should help Ashley obtain and review the applicable easement document and encourage further investigation with the appropriate title, governmental, legal, or other qualified professionals based on her intended use. The existence and terms of the easement may affect what Ashley can do with the property. 2. Why shouldn't Daniel simply tell Ashley that title exceptions are standard and nothing to worry about? Answer. Different title exceptions can have different effects on ownership, use, access, or future plans for the property. Even commonly encountered documents should not automatically be dismissed. Daniel should help Ashley identify and investigate matters important to her and obtain qualified assistance when the legal effect of a document is outside his expertise. 3. Why is receiving a title commitment different from actually completing title due diligence? Answer. Receiving the document only gives Ashley access to the information. She must review the commitment, identify matters that require additional investigation, examine relevant recorded documents when appropriate, and act within applicable contractual deadlines. A title commitment sitting unread in an email does not help Ashley make an informed decision.